Hi, I'm criminal defense attorney Aaron J. Boria, and today I'm going to tell you 5 things you need to know about refusing a breath test in the state of Michigan under Michigan's implied consent law. Let's go. First, what is Michigan's implied consent law? We've covered this on the channel before. Michigan's implied consent law says that if you operate a motor vehicle on the roads in Michigan and you are arrested for driving under the influence of alcohol, drugs, what have you, then you are required to submit to a blood, breath, or urine test upon demand of a police officer. Failure to do so results in serious license consequences. I'll cover those later on. 2. The implied consent law hearing. After you've been arrested, the officer is going to provide you with a form, and at the top it will say Officer's Report of Refusal. The officer will have sent this to the Secretary of State, notifying them that you violated Michigan's implied consent law. At least he says you did. You have 14 days to submit a request. The request can be found on the back of that same form that the officer should have given you. If the officer didn't give you this form, it's still on you to make the request within 14 days of the officer's report of refusal. You can also have your attorney submit a request for you. That's probably the better way to go. At the hearing, the officer has to show up and has to testify. The burden's on him to show that you violated the implied consent laws. You will show up with your attorney. If you want to testify, you can. Sometimes it's a good idea, sometimes it isn't. This will all be done at the Michigan Secretary of State, where there will be a Secretary of State hearing officer. The hearing officer acts sort of like a judge, and they make the final decision in this case. Since 2021, these hearings are now online through Microsoft Teams. So most clients of mine will either come to my office and do them with me through Microsoft Teams, or I'll appear from my office and they'll appear from their home. Simply what you and your attorney decide to do. So what are the implied consent hearing issues? At these hearings, you are limited to 4 issues. That's it. These are the only 4 things that can be considered by the hearing officer when determining whether or not you violated Michigan's implied consent law, and they are as follows. 1. Whether the police officer had reasonable grounds to believe that the petitioner, you, violated driving under the influence law of Michigan. That means that the officer has to establish from viewing your driving, the field sobriety tests he had you perform, whether or not he observed the smell of alcohol or bloodshot, watery eyes. Can the officer articulate to the Secretary of State hearing officer that he had reasonable suspicion to believe that you had committed the crime of driving under the influence? 2. Whether or not the petitioner was placed under arrest for driving under the influence. This means that the officer has to be able to testify that he specifically arrested you for driving under the influence of drugs, alcohol, or some other offense found under Michigan's DUI statute. This means that if the officer arrested you for some other reason, such as driving on a suspended license, possession of a narcotic, or because you had an open warrant, that would not be acceptable. Police officer has to establish that you were actually arrested for DUI. 3. Whether the petitioner, you, were advised of your chemical test rights. What that means is that on these forms that the police officer goes over with you, there are rights listed within here, and the officer will read them to you. It goes something like this. I am a police officer. You are under arrest for the offense of operating a vehicle while intoxicated due to the consumption of alcoholic liquor. I am requesting that you take a chemical test. And the officer will go on and finish to read this. One of the things that a lot of clients have issues with is that they will want to ask questions that these rules don't cover. Many times what the officers do is they simply just read the rights again, because that's all they technically have to do, unfortunately. But that's the issue. Did the officer read this form to the petitioner. Finally, the fourth prong that the officer has to establish is whether or not the petitioner unreasonably refused to submit to the chemical test. This exception is something that we don't win on a lot as defense lawyers, at least I personally haven't, but I have had the situation where a person blew into a chemical test device and the device had an error and was later taken out of service. The officer then wanted the petitioner to blow into another device at a different police station, and at that point they had refused. The argument that we made to the Secretary of State is that the statute does not require them to provide multiple samples, it requires them to provide one sample, which is what they had done in this case. The officer doesn't get to parade this person around the town from machine to machine to machine until they get the result that they want. In that situation, the hearing officer agreed with us, but I can't promise you that every single hearing officer would agree with that situation. I think that is probably more of a case-by-case basis. There are also medical exceptions. If you have diabetes, hemophilia, or if you take an anticoagulant for a health condition, then you are excused from taking a blood test. That doesn't mean that you're excused from taking a breath test, but if the officer demands blood, you could refuse the blood. However, you would have to take the urine or breath sample upon demand. And also, you better be ready to prove this medical condition. If you can't prove it, then you can bet that the implied consent violation will stand. The penalty for violating Michigan's implied consent law. So if you either do not have a hearing, you fail to request a hearing, or if you go to the hearing and you lose, in that situation, your license will be suspended for 1 year and 6 points will be placed onto your driving record. If you lose your implied consent hearing, it is possible to appeal to the circuit court on either the merits of the case or you can seek a hardship license. If you seek a license based on hardship, a circuit court judge in most situations has the ability to change your 1-year suspension into a 1-year restriction. If that happens, you would be allowed to drive to work, medical appointments, court, and education, and anything reasonably related to those things, which can be a big relief to many people. I'm criminal defense attorney Aaron J. Boria, and if you have been accused of violating Michigan's implied consent law, call me today, 734-453-7806. I am ready to fight for you.